Welcome back. A new book written by a Connecticut judge looks at some of the problems within the judicial system and what he thinks should be done to fix them. Judge Thomas Moukawsher is the author of The Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce It. Judge Moukawsher is here joining me this morning. Thanks so much for being with us.
Thanks very much for having me. I'm glad to be here.
So I've got the book. I had a chance to read it. It's a super interesting read, especially if you've ever spent a day inside a courtroom, which is what I do all day.
Yeah.
This is my one hour a week job. But if you've practiced, if you've been in court, if you've had jury duty, if you've had a case there, I think many people can share some of the frustrations you raised in this book. And I thought a line you had right at the beginning, the weeds are choking litigant-centered humanity out of the court. And I think a lot of people who have had a reason to be part of the process, be it civil, family, criminal court, would say taking humanity out of the process, that's a good observation. Why did you start there?
Well, that's because I think there's a fight between formalism in the courts and what I like to call humanism in the courts. And humanism is about taking the human value that's fixed in the law and applying it to the human beings in the case. And formalism is typically about the case itself. The case simply chases its tail for years and years. Did you file the right motion? Did you use the right magic words? Are you fighting over getting documents and things like that? And those are the weeds that are choking the humanity out of the system. And my goal is to try to get us focused on people and the problems that they bring to court rather than about court itself.
And one of the things you talk about, you give 50 suggestions of things that you think could be changed, and a lot of them would require nothing more than the participants deciding to change their ways. You're not necessarily talking about legislating changes or practice book changes for lawyers, more just about changing the way things are done. But one thing you talk a lot about is that idea of finding the solution. And many people have heard of, say, the Dobbs decision that dealt with Roe versus Wade, but they haven't sat and read it. And if they did, it would be very difficult for the average Joe to be able to work their way through there and figure out what all of us in the news media have reported it does. Is that part of the problem?
Oh, enormously, because that's the humanist aspect of the whole thing, is that human beings should be able to read what you're writing, and that people will build faith in the courts if they can understand what we're saying. So legal writing and judicial writing is a critical piece of what I've talked about, and Dobbs is a classic example of formalism. Now, I'm not saying anything about whether the outcome was right or not. It's simply the manner in which we explain ourselves as judges, and whether we talk about form or whether we talk about substance. And I'm for substance is the point.
And do you should the idea be that when a decision comes down, whether it's one that you wrote, say after a bench trial, or an appellate court writes after, oral argument, should it be that the parties can parse out what it means on their own without the lawyers having to say, I read the 25 pages that the judge wrote, and this is what it means?
Oh, absolutely. I think that's exactly what I'm trying to get across in the book. And The Common Flaw is written so that it doesn't have a bunch of jargon in it. People should be able to read what judges say about their cases and actually understand them. And as you as an attorney know, you get many decisions, and this is true all over the country. You get these decisions and you have to guess what the judge was really thinking. And that doesn't help build the faith that I'd like to see growing in our system. We have a basically honest system in our courts, and we should be proud of that. But to understand it is to build faith in it, and I think that's what we need to do.
You gave some real interesting practical examples of things that you'd like to see change, and one of them was to have more remote proceedings. Now, anyone who practices in Connecticut or has had a case in Connecticut since COVID knows the state courts have largely gone to many proceedings being remote. I log in and have a court hearing sitting at my desk looking into my laptop, and something that would have required me to get in the car and drive to, say, Hartford or New Britain or Middletown, now I can do it in 5 minutes, log off, and move on to something else. But you said something interesting that I wonder how you'd wrangle it: remote jury trials. Judge, that sounds really tough to me.
I know that's likely to be controversial, but I think it can work. And I've done many, many remote trials. I haven't done any remote jury trials yet, but I do know that when you're sitting in court and you're a judge and you're trying to monitor what a jury does, you're looking at the side of the jurors, and you can't quite see whether are they paying attention, what are they thinking, are they passing? I can't see what they're doing. But on a remote, you can see absolutely what they're doing. And any time I've talked to a person, particularly retired people who've built up wisdom and things like that and have time on their hands, and suggested, would you participate in a remote jury trial? Oh, I'd love to. They hate going to the courthouse. They hate sitting around. They hate being treated like cattle. But when they actually get to do the business of being on a jury, people love it. And so I think remote jury trials, with the right circumstances, can be a wonderful thing for our system.
The other thing you said that I thought was great and a little self-deprecating, you're a lawyer, I'm a lawyer. A time clock on lawyers in the courtroom. And it reminded me of what they've done in baseball. They put a pitch clock in, and it's been a wonderful success if you're a baseball fan. So the lawyer would have so many minutes to speak, and many lawyers can be quite verbose, Judge. So how would that work?
Well, I use it. I've been using it for years now, and it's a chess clock. So you have a chess clock where you hit one side when one party's speaking, you hit their side, their minutes are winding down. And then the other side speaks, you hit the chess clock on the other side, and their minutes are winding down. The clerk runs it. I found it has enormously facilitated getting cases done. And, lawyers sometimes at first are a little skeptical about it, but most of them have been through it, actually really appreciate it. I had it imposed on me in a case I had many years ago in San Francisco, and I've been a big believer in it ever since.
So even before you wrote the book, you were in the headlines. You wrote a big decision about education funding in Connecticut in 2016, ultimately overturned by the state Supreme Court. In COVID times, mask mandates, you were handling some of the hearings on that. As you look at some of the cases that put you in the headlines, do you think about your 50 goals and say, maybe I should have done something differently?
Well, actually, these cases were a learning process of doing that. In the education case, there were thousands of exhibits offered. I forget, it was 4,000 or something exhibits were offered in that case. And by working with the parties to try to admit things that there's no dispute about, we got that down to about 800, which in retrospect, I'd say you can get it down to about 50. So you learn things as you go along in dealing with complex cases. And in that case, I learned that. And I learned an awful lot about the separation of powers and our checks and balances in doing the mask case, which was about the governor's authority. And handling that from the judicial perspective also informed what I did with the book.
Only about 30 seconds left. Super interesting if you're a lawyer or a judge, but who do you hope will buy this, and who's
as
supposed
many
to read
people
it?
as possible. But the public should be able to read this book, and I wrote it so that the public would read this book. It's a look behind the courthouse door. So if you're interested in how a lawsuit actually works and you're not a lawyer, you might find this interesting. But undoubtedly, lawyers and judges would be the right audience to read it. But I've written it for everybody.
All right. Well, like you said, you're the author, so everybody should buy it. I think that's a smart policy. Judge Thomas Moukawsher, thank you for being with us on CT23. Again, the judge's book. It's The Common Flaw, like the common law, but with an F. The Common Flaw, needless complexity in the courts and 50 ways to reduce it. You can find it online or order it at your favorite bookseller.